Hi, Anushri. Good to see you here. I hope you can hear me and see me clearly. I hope the voice is audible. Hi. Hello. I hope you all are safe. I hope you all are at home. I hope you all are taking precautions and, stepping out only when necessary. And I hope you all are enjoying the winter that has come to Delhi. Thanks, Himanshu. I hope you can see me and hear me clearly. Yes, guys, just indicate with a thumbs up if you can. So many waves. Okay. All right. I hope you all are enjoying the webinars that we are organizing for you all, and I hope we're helping you learn and improve your knowledge of law. I am waiting for our guest today to join, and I see that he is here. So Arnav, if you can send me a live request. Yes, you sent it to me. Okay, so before I patch him through, I will tell you, Mr. Arnav Narayan is an advocate on record with the Supreme Court of India. He is an expert when it comes to consumer disputes and has been practicing quite regularly at the Consumer Forum. He is also someone who's done his master's from Cambridge in competition law. And I've been getting after him to do a session on virtual lawyer for quite some time now. And finally, today we managed to sort of modules and make sure that we're here together. And hi everyone. Hi Auntie. Hi Aditi. Okay, Arnav, I have patched you through. Just let me know if you're here. Hi Ishita. Okay. So it looks like we're waiting for Arnav to join. Today's discussion will be on consumer disputes, and it's going to be an in-depth account of what exactly are consumer disputes and how do they get resolved and what are the forums and what are the new laws and all the technicalities in the consumer forum. Okay, Arnav, you'll have to send me a request again because for some reason you could not join. Hi. Arnav, if you're here, just send me another request. I hope he's here. If you all have any questions or any suggestions for us, you can always send us a direct DM on the virtual lawyer. And I promise we will get back as soon as possible and sort of help you all in that aspect. Oh, there you are.
Hi, Jahnvi. I hope I'm audible.
You are audible and you're visible.
Wonderful.
Yes, okay. So after a very long introduction, which was not long at all, I will move on to your first question. Just to clear the basics, what exactly by a consumer, like for had to a lay person? How would you explain?
So, consumer disputes, before we go into consumer disputes, it's important to understand where do people meet this law? Right from the time you wake up, you brush your teeth, to the toothpaste you use, to the brush that you use, to the mobile that you use. These are all products which surround our daily lives. And if something goes wrong in these products or any service that we are sort of receiving from a company, if there's any problem with regard to these services or products, if there's any shortcoming, if there's any imperfection, that's where consumer disputes arise. For example, let's take a very basic example of a mobile phone. If my mobile phone starts malfunctioning, I'll basically go to the consumer court to file a complaint saying this is something which was not promised to me, and it's not the quality that was represented, and therefore that begins a consumer dispute. Another example can be, let's say you purchased a property and you purchased it like 7 8 years back, whereas the contract said that they'll give you your property in 3 years. This again has elements of deficiency in service and it amounts to a consumer dispute. There are numerous examples like if you don't get mobile network, you can sue the telecom company saying it's not the network that you're promising. There's a misrepresentation, and therefore I want to sue you in the consumer courts.
Okay. Okay.
So yeah, I mean, any basically the important thing to keep in mind is the person suing a particular seller has to be suing for a good or a service. Goods include everything under the Sale of Goods Act. It's a very, very broad definition. So goods can be a mobile phone. It can also be a software. It's not tangible. You can't see the software, but you can still sue. So it's got a wide definition. And even for service, I mean, from housing construction to telecom to medical negligence to restaurants, like services extend to a wide range of things. And yeah, that when you're not satisfied with these services or there is a fault or imperfection in these goods, that therein lies the consumer dispute.
Okay. Okay. So if, for example, consumer dispute that one is dealing with, so where all can one go to seek to seek redressal or to sort of sue someone, like you said, and
Right.
how would we know which forum is more appropriate? How would we figure?
So, in order to answer that question, you need to understand that why this law came into force. Why do people need a consumer law? Well, the short answer to this is that if you go to a civil court, the case will be pending for like a very long time. There will be procedural difficulties. The civil courts are already clogged up. So the legislature, in its wisdom, thought that they should have a specific law to protect consumers, which will provide for a specific forum for them. Now, this forum will not be bogged down with heavy procedures or too much legalese. They will simply look at the grievance of a particular person, a consumer, and they will make the corporation or a company answer. Now, to answer your question, the Consumer Protection Act, which is 2019, recently it's been amended and the old act has been repealed. Under the Consumer Protection Act, the hierarchy of forums is this. At the lowest level, a person can go to a district consumer commission. Now, the person who goes to a district consumer commission, it's in every district in India, and the value, the pecuniary jurisdiction has recently been changed. You can only go to the district forum for disputes which go maximum up to 1 crore. So if it could be a mobile phone or it could be a property worth 90 lakhs. For that, you need to approach the district forum. The next is the state commission. The pecuniary jurisdiction of the state commission is between 1 crore and 10 crores. And finally, the National Commission, which takes up cases which are worth over 10 crores. So the value of the goods and services has to be above 10 crores. What is important to remember is that in 2019, the new law has come into force. Earlier, what used to happen is that a person who wanted to sue a company had to go to the district forum or the state commission of the state where the company has its registered office. So it was a big problem for many people who lived abroad or lived in different parts of the country to sue a particular company. And then the company would take objections of territorial jurisdiction. That entire issue has been done away with under the new law. Today, a consumer can file a complaint where he resides or where he carries on business for gain. So if I let's say reside in Defense Colony, the closest district forum to me is a particular district forum. I go file my complaint there. Now I don't have to be bogged down with the issue of having to go somewhere where the company's registered office is and file the case there. And the second thing is that the new act has brought in is you can file a consumer complaint electronically now, as per statute. and that has reduced a lot of burden on
For the cost of paper and wasting paper for the
Absolutely, absolutely. You're saving paper. You're also, you must remember, consumers are not just us who are video conferencing. They are like poor people in villages who are trying to access justice. So for them to be able to go to their district and file a consumer complaint means quite a bit. So yeah, I mean, to basically answer your question, this is how you approach a consumer forum. This is the hierarchy of the consumer forum.
Okay. Okay. So Arnav, like for example, you've spoken about the amendment of the Consumer Protection Act, right? And you've
Yeah,
spoken
yeah.
was an act before this which had certain kind of provisions. But tell me something. Why do why separate act for consumer disputes? Why do you think that need
Your voice is cracking, Jahnvi. If you can just repeat that.
Hello, can you hear me?
Yeah.
Okay. So why do we have the need to have a separate act or separate law for consumer disputes?
So, like I said before, you don't need an act. I mean, you can go to the civil court and pursue a recovery suit or a permanent injunction suit. But the problem with that will be that you'll file a case today, you'll file a suit today. The procedure is such that it'll be listed after months. The written version will come after months. The evidence will be led after a long time. Then there'll be cross examination. There'll be examination. Then you'll have to file a rejoin. I mean, the procedure will go on for many years. And the problem with that is that many people can't afford to sort of wait for so long in order to redress their grievances. And therefore, the consumer fora have been established to provide a summary procedure. What that basically means is it will be dealt with in 3 months. In 3 months, every consumer complaint should be completed and finished. That is the mandate of the law. I mean, whether or not that happens, you and I know that even in consumer forums, it will go on for at least a year or 2 years. But that's still better than going to a civil court, according to me, and pursuing your remedies for a very long time. So yeah, I mean, and the second thing is that civil courts are already burdened. They're already clogged with so many matters. We know of the problem of pendency being faced by civil courts, and to avoid that, they've provided a specialized forum to address these grievances.
Okay, so according to you, who can approach a consumer forum?
Uh, so basically, a consumer approaches the consumer forum to answer that simply.
Yes.
But who the consumer has been provided under the Act. Now, Section 2.7 defines a consumer. I won't go into the details of that section, only to tell you that any person who buys any goods for a consideration, or a person who is a user of these goods, basically, either you've purchased these goods, and in some cases, you may not even have purchased these goods and you're just using those goods. For example, so many times there is a machine which comes into the house, let's say a washing machine. Now, you may not have personally purchased that. Your parents or somebody in your family might have purchased that, but you're the user of that good. You're a beneficiary of that good. And therefore, you get qualified under this act to be called a consumer, and you can approach the consumer court if there is any fault or imperfection with that machine. The other is with services. Any person who hires or avails any service for consideration. It's important to note that consideration is important. You have to be. It can't be a free service, or it can't be a free good that somebody is gifted to you. There has to be an element of consideration involved in both the goods and the services. And the other important factor is that you've purchased this not for commercial purpose. I'll just spend a minute to tell you what this means. This basically means that if I am running a small business, right? Let's say I'm running the business of manufacturing photocopying machines. I cannot purchase photocopying machines from a big company and be a retailer of those photocopying machines and later come to the consumer court saying that I have purchased this from the manufacturer and I am selling this as a retailer, but I am a consumer of the manufacturer. The problem with that is you have purchased a machine for commercial gain. You're running a business. So most business enterprises who purchase anything for commercial purposes will be excluded under this act. This act is not for people who are running commercial undertakings. It's for poor people, for people who can't afford too many remedies, for people who are purchasing goods and services for themselves, for their own use. But the one exception, even to the exception of commercial purpose, is if you can prove to the consumer court that you've purchased a particular thing for earning your livelihood by means of self-employment. I know this is a lot of words. I mean, this sounds like completely complicated. I'll give you a very simple example. There was a gentleman who purchased a truck from a company, and there was a problem with that truck. So he went to the consumer court and he sued the company, the company that made the truck. The trucking company came to the consumer court and said, "Boss, he's not even a consumer. He's running a business of trucks. That person should be excluded from the consumer disputes and the consumer forum." That person said, "I am not running a trucking business. I am a driver of a truck. I've only purchased one truck and I drive this truck to earn my livelihood. And I am driving this for by self-employment. It's not that I've hired a couple of people to drive that truck." So he was able to give an exception to the exception of commercial purpose and say that even though I am not using it personally, I'm using it as a business, but it's basically to ensure that I can earn my own livelihood by means of self-employment. And therefore, he was considered to be a consumer. This is a pretty big case in the Supreme Court. To answer your question simply,
Oh, now we come to simple.
yeah, to answer your question simply, a consumer will include any natural person. Okay, it will include a corporate entity. It can include a Hindu undivided family. It can include a firm, whether registered or not. It can include an association of persons, whether registered under the Registration Act, or any artificial juridical person. So there is a host of people who can come to the consumer court, not just a natural person, but these juristic persons as well.
Okay, so Arnav, like you've spoken about different cases, but I can't help but notice that these cases also include different subject matter. For example,
Correct.
there is real estate, there is telephones, and you know, there's
Telecom.
telecom, there is
Yeah,
insurance.
yeah,
So these are
yeah.
all very like varied subject matters. So how do
True.
you feel? I mean, according to you, do you think consumer courts are equipped to deal with such a variety of subject matter, or do you think it clashes with like other quasi-judicial entities?
This is a very good question. The consumer court actually takes care of a number of subject matters. And the beauty of this forum is that it doesn't have to be an expert in all these issues. It's a summary forum. It listens to your disputes, and to the best of their abilities, under the clauses provided under the Act, they decide these cases. Now, let's take, for example, a case of real estate disputes. There is a body called the Real Estate Regulatory Authority, RERA, which is provided specifically for real estate disputes. We've got the Telecom Regulatory Authority of India, which is dealing specifically with telecom. Similarly, there would be many other statutory and judicial authorities which would be dealing with special acts. Despite these, the Consumer Forum has the power to deal with these subject matters so long as they sort of revolve around issues of unfair trade practice and deficiency in service. How does the Consumer Court get that power? Now, interestingly, there is one section in the Consumer Protection Act 2019, Section 100, which is akin to Section 3 of the earlier Act, the repealed Act 1986. This is the section which gives power to the Consumer Forum, because this says that the remedy under this law is in addition to and not in derogation to any of the laws which are currently in force, which basically means that this is an additional remedy. Regardless of whatever remedies are available under the law to you, consumer remedy is an additional remedy. It is not going to supplant the already existing remedies. It will supplement them. That's what the Supreme Court says. It's an added remedy. And even recently, in the case of Imperial Structures versus Anil Patni, the Supreme Court has held, despite there existing Section 79 of RERA and a special remedy, that does not bar your remedy under the Consumer Protection Act. So it's very, very important that people know that the consumer remedy is an additional remedy. Often, as real estate lawyers, we get this query quite a bit that should we go to the RERA? Should we go to the consumer court? So, in my view, going to the consumer court, nobody can stop you. You can go there in any case. The only controversy which remains is, can you pursue both the remedies? There are different lines of cases which say that the different high courts have held that, yeah, you can pursue both remedies. And there is a line of cases which says, no, you choose your remedy and stick to that remedy. But as far as different laws are concerned, the consumer court's jurisdiction is saved. And there's also a very interesting provision in the Telecom Regulatory Authority Act. In the TRAI Act, there's a section 14 which protects the consumer's jurisdiction under the Consumer Protection Act. So if there is a dispute that a consumer has against a telecom company, if he's an individual consumer, the TRAI Act says that he can easily approach the consumer court. He doesn't have to come here. But if it's a group of consumers and they're espousing a cause for a larger number of people, then Section 14 says that the consumer remedy will not be available. Then you have to come under the TRAI Act. That's statutorily, it bars a group of consumers under the TRAI Act. All this still has to be tested in the consumer courts.
Okay.
So, yeah.
So I'm sure you'll be around to tell us what happens when it gets there. Okay,
Yeah.
so I have
Unfortunately,
another question.
for corporations, we have to take all these objections. And my work as a lawyer for companies is basically to take these technical objections and make the life of consumers miserable. I apologize for that, but that's why I'm doing this.
You can do justice by doing some pro bono consumer cases.
Exactly. Yeah.
You can do that.
Absolutely. I will.
Okay. So yeah. So according to you, what are the most significant changes or developments that have taken place as a result of the Consumer Protection Act?
This is actually the most important question. The law has recently changed in 2019. And as a result of the change in law, there are a number of new things that have come up under the consumer protection jurisdiction. And the biggest event that's happened is the change in pecuniary jurisdiction. We don't know why, we don't know how. There is no debate in Lok Sabha, there's no debate in Rajya Sabha about why the pecuniary jurisdiction was suddenly changed. Now, firstly, under the 1986 Act, the pecuniary jurisdiction, as I've already said, of the district forum was up till 20 lakhs. Then State Commission was 20 lakhs to 1 crore. National Commission was above 1 crore. But under the new law, the district forum has got 1 crore. The State Commission has got 1 crore to 10 crores. And the National Commission has got above 10 crores. So essentially, the district forum will be extremely burdened. And apart from the fact that there's been a change in pecuniary jurisdiction, it raises a question: what will happen to the pending complaints in the consumer court? If I filed a complaint which has yet not been decided, will this pecuniary jurisdiction change my
structure, the infrastructure of the district forum?
Absolutely, absolutely. No, the answer is no. I can tell you the National Commission itself is in a bad state. There is, in fact, a writ pending in the Supreme Court bringing to notice the bad and sorry state of affairs that's throughout the country with regard to consumer courts. There's no infrastructure. And now with this amendment, they've brought in to so much burden on district courts when in fact they may or may not have that infrastructure. So it's something to be discussed. And as far as the pending complaints are concerned, the president of the National Commission is clearly of the opinion that nothing happens to the pending complaints because of Section 107, read with Section 6 of the General Clauses Act. I'm not going to go into that.
Okay.
Yeah, it's a whole long discussion about whether or not pending complaints get affected. And I'll just give you a primer on what the controversy is. People feel that if you force me now to go to a district court, even though my case is pending in the National Commission and the jurisdiction has changed, I have to go to the district forum. then my rights will be affected, and I'll have to go to another forum, I'll have to file the complaint again. But there is another, and that's going to be burdensome. So the courts feel that there's no purpose that will be served. The other school of thought is that the change in the forum or the pecuniary jurisdiction of a forum does not affect the substantive rights of people. You will still go to the district forum, they will still give you a patient hearing, you will still win your case, only in a different forum now, not National Commission, but in the district forum. So that debate again is up for grabs. It's going to happen quite soon. The second change, which has happened as a result of the new act, is earlier the district forum and the state commission didn't have any powers of review, and there was a judgment to that effect. So if there was a final order passed by the state commission, I could not file a review petition before the state commission saying that there is some error apparent on the face of the record. You had to file an appeal to the National Commission, unfortunately. Now that has been done away with. All three forums, the district forum, state commission, and the National Commission, have the power to review their own orders. So that's number two. The number three, and another very significant change that's happened, is they made a central consumer protection authority. They made a regulatory arm of the consumer courts in India. Like under the Competition Act, you have the Competition Commission of India, but you have the investigative arm of the CCI, which is the DG, Director General's Office, who does investigations and things, who can penalize you, who can conduct search and seizure. Similarly, under the Consumer Protection Act now, you have an authority established in order to investigate any issues which involve class action. So if a class of people, let's say the Maggie case, if it comes today, and people file a complaint before the Central Consumer Protection Authority saying it's got MSG, it's got something which is harmful or hazardous to people's health, this body can investigate, find a prima facie case and investigate, call for testing. It can ask, it's got wide powers of penalty. It can do a search and seizure. It can ask for returning of goods. It can ask for replacement of goods. And therefore, this regulatory body has made consumer laws even more strict, because now the consumer courts can actually come into your company, come into your manufacturing plants, seize things, and take samples and haul you out. They can impose penalties which range from 10 lakhs to 50 lakhs. And also something very interesting, the fourth change which the new law has brought in is, and this is one of my favorite changes, it brings the endorsers of goods and services under the ambit of this act. All your Katrina Kaifs, Shah Rukh Khans,
influencers,
all your Instagram influencers who are endorsing products, everybody comes under the Consumer Protection Act. And if you give a false endorsement, sorry?
This is why we only endorse people like you on Virtual
That's
Lawyer.
right. That's right. But if you are endorsing a product, let's say you're endorsing a sanitizer, which is nothing but water, you'll be hauled up. And the kind of penalties that can be given to an endorser will include things like a daily fine of 1 lakh. They'll be ordered not to endorse that product anymore. They'll be refrained from endorsing any product for a period of time. So a lot of penalties can be levied on endorsers of these products. The only exception is if the endorser can prove, according to me, this product is what they represent it to be. And in my limited knowledge, it was absolutely fine. If you can prove that to a court, then you won't be hauled up. And so again, another very important change that's come in, I've already discussed this, is consumer complaints can be filed online now and from where you stay. Like literally a stone's throw from where you stay. Another very important change that's come into the new act is product liability. So what was happening was a lot of manufacturers were being sued. Let's say a manufacturer of a motor vehicle, my car was giving problems the moment I purchased that car. There was a case of manufacturing defect, but that was not the only person who was liable. Not only was the manufacturer liable, the seller of that product and the service provider of that product was also in fault. And how did that happen? Let's say the seller of that product made some modifications in that car, and that resulted in my product being sort of faulty or started falling short. So that product liability brings in three aspects: the seller, the service provider, and the manufacturer. All three will be held up for, and you can't say, boss, ye meri problem nahi hai, it was the manufacturer's mistake, I'm only the seller or the service provider. That defense is no longer available. Then I'm sorry, there's like a long list of
No, no.
changes that have come in. Another very important change is unfair contracts. Before this, under the old act, unfair contracts was not a specific provision provided. Even though consumer courts under the old act were still holding contracts to be unfair under the Contract Act, now there's a specific clause for unfair contracts under the new law. What does that mean? If you have purchased a residential property in Gurgaon, the builder said you sign a particular agreement. You signed it because you're excited to buy this property. You don't question what clauses are there inside that contract. And later on, you find out that there is no clause providing for a timely delivery of your property. There's no clause for compensation to you in case the property is delayed. There is no clause for terminating this contract. And the compensation that you have to pay to the builder if you delay in making payment of your installments is exorbitant. These contracts are now covered by the Consumer Protection Act. You don't have to worry about such contracts. If you've signed such contracts, you can easily approach the consumer courts for such contracts. And you even earlier, you could have approached the consumer courts. Only now specifically, the authority can hold a particular contract to be completely null and void, and you will be compensated for any damages that have been caused to you. Yeah, I mean, there are some more. Another very interesting is the provision that's been added is mediation. Often in consumer courts, when we would argue against complainants, the court says, why don't you try and settle the matter? Now there are specific rules provided under the Consumer Protection Act 2019 that if the both parties want, a special mediation cell will be attached to every single consumer court, which is district, state, and national commission, and parties will try to settle the matter through mediation. So yeah, that's also been added. There are many other changes which I can provide you a document on that.
Okay. Okay. All those interested, please DM us. We will provide you that document.
A comprehensive document.
A comprehensive document. Good luck reading it.
Yeah.
Okay, so now that you've spoken a little bit about mediation, it brings me to my next question, which I wanted to ask you about. So like, of course, we have the consumer disputes and in the consumer forums, and that is the traditional and conventional form of litigation. But you know that there is alternate dispute resolution. You've been a part of one of those. So what would your view be on, let's say, arbitration, mediation, conciliation vis-a-vis commercial contracts?
So it's very interesting. In the consumer universe, we had raised this objection has been going on for the longest time. And I'll explain a little bit on what this issue is. Whenever a complaint was filed in the consumer court, the companies, the opposite parties would come to the consumer court saying that you don't have jurisdiction to hear this case. There's an arbitration clause in the contract between the consumer and the company, which basically means we are now enforcing that arbitration clause and we need to be sent to arbitration. Please appoint an arbitrator. The consumer courts, since time immemorial, have been holding this to be a bogus objection. They've basically been saying you can't force a consumer to go into mandatory arbitration just because you inserted an arbitration clause. So the Supreme Court has always been of the view that you can't force consumers to go in for arbitration. It's an expensive remedy. It's a very difficult remedy for a person who can easily, pay 0 rupees to get his consumer complaint heard. There in arbitration, you have to appoint lawyers, arbitrators, pay their fee. So that objection under the old Act, 1986 Act, was taken for a long period of time. But then the Arbitration Act was amended, and the words notwithstanding any judgment, decree, order of the Supreme Court was added in Section 8. And all these companies came back running to the consumer court saying now that the Arbitration Act has been amended, please send us for arbitration. And they were very excited that now the act has amended. The legislature wants all such cases to go in for arbitration. None of that was happened. In fact, I was dealing with this case. I briefed Fali S. Nariman. I mean, it was a wonderful experience working with him. He also agreed that Section 8 of the Arbitration and Conciliation Act will completely overshadow the consumer courts. And this is a case worth fighting. We took it right up till the Supreme Court, but the Supreme Court, according to me, passed a judgment which was questionable in terms of the fact that they've now held consumer disputes to be non-arbitrable totally. So everybody asked, how can you hold something like that? How can you hold disputes to be non-arbitrable when even under the earlier law, nobody held it to be non-arbitrable? That question is still out in the open. What the Supreme Court has said is that if both the parties want to do it willingly, they can go in for arbitration. They can go in for mediation. But then I ask myself, if you've held a dispute to be non-arbitrable, how can parties agree to go in for arbitration? So I'm still asking myself that question. I don't know what the answer is. But one thing which I can say with a lot of certainty is that alternate modes of dispute resolution are preferred, are encouraged in the consumer courts on a daily basis. And we have settled matters, we have settled hundreds of matters through mediation, through alternate modes of dispute resolution. So it's something that the consumer courts have been taking seriously, only now they have specific guidelines for it.
Okay. So please tell us a little bit about your experience briefing Mr. Fali Nariman. I'm pretty sure all the young lawyers and senior lawyers here are like dying to know what that is like.
That was my big fan moment in my profession. I felt that I have arrived if I brief Fali Nariman. What happens is that you can't just brief him. His office will ask for a small note, a half-page note to just summarize the case you want to brief him for. If that note is accepted, he'll appear for you. If he doesn't like your case, then he'll say no. He, as it is, takes very few cases. So we sent that note, and I got a call from his office saying that boss wants to keep a meeting, a conference. We sent him the documents, and then began one of the toughest briefings of my life. I mean, we were all, as it is, shivering when we sat with him, and it was like a scene from Godfather. Like he's sitting on his round table, all of us are sitting next to him, and he goes through each and every word, each and every page, each and every document so meticulously, even at this age, that it's a very inspirational sort of experience for any young lawyer, any lawyer. And there were times when he shouted, there were times when he praised us. It was like a whirlwind of emotions. But at the end of it, I think we came out better prepared and sort of better suited to argue that matter. And this was the arbitration matter, that the fight between arbitration law and consumer law. And yeah, I mean, that's what you can expect out of such a fine lawyer. And yeah, I mean, if you get a chance to argue before to brief Fali Nariman, I feel take it with both hands.
I think that'll be my dream. Like that would be my dream if I get a chance to brief him ever.
Absolutely. Because I was reading that briefing, and every single time he praised us, we left that room thinking that I think this is it. Like this is the best you can feel as a lawyer.
So what was the one thing about that he said to you that sort of like stuck to you, that sort of like, you know?
Well, after we got a stay in the Supreme Court, in a matter where nobody would give us a stay, we were able to build up that case and actually get a stay of all the consumer cases. I remember waiting outside the corridors of the Supreme Court to just thank him for arguing.
I think I met you that day.
Yeah, and he basically, my father was speaking to him, and then he said, "Where's your son? Please call him." I went up to him and he did this. He said, "Good work," and I was like happy.
That's it. Life is set.
That was the high point.
I would faint. Like at that moment, that would be my fainting moment.
I went back home and I fainted. I was like, I'll wake up a couple of weeks after.
Okay, yeah. Arnav, thank you so much for answering such tough questions so eloquently and so smoothly and so simply for everyone. I know you're a
Thank you.
busy person and I know you have a lot of conferences lined up, but if you want, we can answer. There are a couple of questions in the comments. If you want, we
So
can answer.
the thing is, I would love to answer them. I think I've already prepared a couple of things for your viewers.
Yeah.
What I can do is I can circulate this note, which perhaps might answer some of those queries, and you
Yeah.
can share them with whoever wants them at the virtual lawyer platform.
Yeah.
And yeah, I mean, if there are any specific questions, then I can personally take them. I can give my email
Yeah,
ID to
so
you.
you all can DM us at the virtual
Yeah.
lawyer, and
Yeah.
we'll forward you sir's email ID, and you can contact him directly. And for those of you who are on the groups, I can forward the comprehensive document via WhatsApp or via email. All
And I
right,
just want to thank you and Dr. Batra and your entire team for having me on. You're doing
thank you.
something really, really amazing. You've made extremely good you've made good use of this time in the pandemic by
Yeah,
creating
what
this
to
virtual
do?
platform. Absolutely,
What to do? We can't physically meet, so we have to find other alternatives.
absolutely, absolutely, and kudos to you for that. So thank you.
Thank you, and thank you so much for being here, and thank you for finally we managed to schedule this interactive
Yeah.
session. I think
We
it's
will,
pending for like the
yeah,
longest
we can
time.
actually do another one
We
sometime in
will.
the next week.
Yes,
Yeah.
see, we're already getting
Yeah.
comments. We've got a lot of comments saying that they really loved the session. If you all want a follow-up session, we can do one. And I
Yeah,
also
we'll
want you to do
organize
a
something.
session on competition law.
Yeah, yeah. Let's do that. Let's do a session with competition. Cool.
Okay, all right. Thank you,
Right.
Arnav.
Thank
See
you.
you.
See you. Bye,
Bye.
guys.